This conference will now be recorded.
Welcome to AI Answers, weekly updates from the world's leading valuation authority. Today is October 14th, 2020. My name is Bill Garber, Director of Government and External Relations of the Appraisal Institute. Today we're discussing legislative and regulatory developments in appraisal labor, which will delve into the realm of employees and independent contractors within real estate appraisal. With the gig economy and the advent of Uber and Instacart, some state governments have amended labor law to promote or protect employee rights or benefits. Some unintended consequences have occurred from this, including in real estate appraisal business operations, which have benefited from the flexibilities associated with independent contractor status. The California State Government Relations Subcommittee of the Appraisal Institute worked hard this session with others to craft an amendment to a landmark California law, which we hope will serve as a model for other states to follow in exploring gig economy labor issues. So we'll talk about that today, and further we'll also cover some federal activity that may have impacts on this issue. I'm joined by my colleagues Scott DiBiasio and Brian Rogers in the Appraisal Institute Washington office. Scott is the Manager of State and Industry Affairs, and Brian is the Manager of Federal Affairs. Thanks to you both for spending time today, and thanks for your work and on your insights on this important issue. Scott, let's go ahead and start with you at the state level.
Great. Thank you very much, Bill. And I appreciate the opportunity to be on AI Answers again. So today we're taking a look at an issue, the classification of workers as employees or independent contractors for purposes of federal, state, and in some cases local employment-related laws, specifically the collection of income taxes, the FICA tax. We're also talking about the provision of unemployment insurance, workers' compensation insurance, so on and so forth. And this is an issue that is applicable to some, but not all appraisers, appraisal firms, and appraisal companies, and appraisal management companies. So you may be thinking right out of the box here, okay, that's great, but how does that affect me as an appraiser? And I did want to say right at the beginning here that if you are an appraiser that is retained to do appraisal work for a bank, a law firm, a state or local government, a utility, or really any other hiring entity that is not an appraisal company or an appraisal management company, then most of what I'm about to say here today will not necessarily apply to you. Appraisers in those types of work relationships are almost always properly classified as independent contractors. Further, many, perhaps most, appraisal firms and companies have staff appraisers bring those folks on as employees and deal with the myriad of employment-related requirements that are requisite to having employees. What we're mostly talking about here today is a small subset of appraisal firms and appraisal companies that retain individual appraisers on an independent contractor basis. We're also talking about appraisers that work in the appraisal management company space. So while the objective of today's program is to take a look at a new law that was recently enacted in California, I think it's important to provide some context and some history. We're also going to take a look at how this California law could impact individual appraisers working in other states. So let's go ahead and get started. I think it goes without saying that there are monetary benefits for employers, mainly in the form of eliminated payroll and Social Security taxes, by having the luxury of classifying workers as independent contractors. This is true not only in California, but in just about all other states as well. So I think it's important to provide a little bit of a history and context for the new California law that we're going to talk about here in a second. In 1989, the California Supreme Court wrote a decision in the case of S.G. Borrello and Sons versus the Department of Industrial Relations. I don't think it's necessary really to review the facts and circumstances of the case, However, what the outcome of the case was is what is important for this discussion. In this case, the California Supreme Court found that the test of an employment relationship is whether the person to whom service is rendered, and I'm quoting directly from the case, has the right to control the manner and means of accomplishing the result desired. The Borrello case also established an 11-factor secondary test that could be used to determine whether a worker was, in fact, an independent contractor or an employee. I think it's important to note that no one factor in the 11-factor test is determinative, and the factors must be evaluated in their entirety. And this is very similar to the test used by the Internal Revenue Service. I'm not sure how many factors they have, but the IRS test is also based upon the totality of the circumstances, and no one factor is a determinant either way. So this case, Borrello and Sons, established the common law test for employment in California. And under the Borrello test, some employment relationships between appraisers, appraisal firms and companies, and AMCs satisfy the requirements to be independent contractor relationships. Although I think it is possible that some of these independent contractor relationships between appraisers and appraisal firms may have been a little bit of a stretch of the Borrello test. So let's step forward a little bit to 2018. The Borrello test was obviously in place from when it ruled on by the California Supreme Court in 1989. And along comes another case that was testing the employment-related laws in the state of California. It's known as Dynamex Operations West versus Superior Court. And again, the facts and circumstances of the case really aren't relevant to this discussion. But what is important for this discussion is that the Dynamex case established what is referred to as an ABC test for purposes of determining whether to classify workers as employees or independent contractors. Generally, the ABC test requires that there is a presumption that a worker is an employee unless the hiring entity can satisfy each and every one of the three factors in the ABC test. Unlike the Borrello test, which required an evaluation of the totality of the circumstances, not satisfying any single prong of the ABC test would then require that a worker be classified as an employee and not as an independent contractor. The three prongs of the ABC test are that, one, or A worker must be free from the control and direction of the hiring entity in connection with the performance of the work. And this has to be both under the agreement for the provision of services and actually in fact. B, the worker performs work, and this is an important note, the worker performs work that is outside the usual course of the hiring entity's business. And that's the prong I'd like for you to remember as we go through a little bit more of this discussion. And C, the C prong is that the worker must be customarily engaged in an independent trade or occupation. And that has to be of the same nature as the work that is performed. So for employment relationships between appraisers, appraisal firms, and appraisal management companies, the B prong of the test is what becomes the issue in classifying workers as independent contractors. There is a legitimate question as to whether or not an appraiser performing appraisal services for an appraisal firm or company is engaged in work that is not outside the usual course of the appraisal firm or appraisal company's business. As it relates to AMCs, there is also a question about whether AMCs engaging appraisers are similarly engaged in the business of providing appraisals, or whether they are engaged in providing technology to assist the appraisal process. If those AMCs are technology companies and not appraisal businesses, then the relationship between those appraisers and the AMCs would in fact satisfy the ABC test. On the other hand, if somebody, a state agency, were to determine that AMCs are in the business of actually providing appraisal services, then those appraisers that are actually performing the work for those AMCs would not be in a different line of business and would be in the same business of providing appraisal services, and therefore they would not then satisfy the B prong of the test and would have to be classified as employees. So when the Dynamex case was first decided, we began to hear from appraisers and appraisal firms that it could potentially present a problem and that Dynamex could potentially disturb some long-standing independent contractor relationships between appraisers, appraisal firms and companies, as well as AMCs. In the calls expressing concern with the new policy that was adopted in the state of California grew even louder 1 year later in 2019 when the California legislature passed Assembly Bill 5. And what Assembly Bill 5 was a codification of the ABC test. So the Supreme Court issued a decision. The California legislature then took pretty much verbatim the elements of the decision in Dynamex and codified them into the laws in California. And again, it's a near verbatim codification of the ABC test. When AB 5 was enacted, there were some exemptions from the application of the ABC test that were included as part of the legislation. But unfortunately, appraisers were not part of the exemptions, although some other similar occupations and professions, such as attorneys, accountants, and architects, were included as part of the exemptions that were included in AB 5. So now let's talk a little bit about what happened since the passage of AB 5. It became abundantly clear very quickly that, again, there were some issues with the application of the Dynamex decision to the way that workers in appraisal firms and within appraisal management companies are classified. And those relationships obviously were traditionally independent contractor relationships. So as Bill mentioned in his introduction, the 5 California chapters of the Appraisal Institute, formed as part of the Appraisal Institute California Government Relations Committee, decided to undertake a lobbying effort to obtain an exemption for appraisers from the application of the ABC test, much as was the case with the accountants, architects, attorneys, and so on. And I'm happy to say that that lobbying effort was successful and resulted in the passage of AB 2275. Obviously, there were a lot of other things that are included in AB 2275 besides the appraiser exemption. But the AIC GRC in California was successful in having an exemption for appraisers included within the language of AB 2257. So when this law became effective back in September, it was an exemption for all appraisal relationships from the application of the ABC test. One thing that I think is important to note, however, is that AB 2257 is not a universal approval of all of the existing independent contractor relationships between appraisers, appraisal firms, and AMCs. The exemption within AB 2257 has some prerequisites, and there are 6 of them that need to be examined and invoked before an employer can properly classify a worker as an independent contractor. And one of those factors, like I said, there's 6 of them. One of them is that the worker, in this case, the appraiser, has to have their own independent and separate place of business. And it's kind of interesting that the law specifically says that a home office does satisfy that requirement. And I'm not sure if that was in recognition of the pandemic and the fact that many appraisers are working from home, and that many work from home full time anyway. But I did find it kind of interesting that they did clarify specifically in the law that a home office that does satisfy that provision of the 6-factor test. And once those 6 factors are satisfied, then the relationship reverts back to the Borello test. In other words, once a hiring entity has satisfied those 6 factors, now they can resort back to the use of the 11-factor Borello test. And as I mentioned a little while ago, not all relationships between appraisers and appraisal firms and companies could satisfy the Borello test. Now, there are some of those relationships that legitimately do satisfy the Borello test, and it is appropriate to classify those workers as independent contractors. But I think it's very important to remember that AB 2257 isn't just a universal statement that appraisal firms, companies, and AMCs can hire appraisers as independent contractors. There are several factors, 6 at the outset, and then the 11 contained in the Borello test, that do need to be satisfied before those workers can be classified as independent contractors. So now California is in pretty good shape with the exemption that was enacted as part of AB 2257. However, appraisers in the 54 other jurisdictions really need to be vigilant for similar proposals that may be working their way through the process in their states. There are already 33 states that have some form of the ABC test in place. But what is interesting in those 33 states is that the B prong, the one that presented such a problem in California, states that if work is performed off premises from the hiring entity, then that work is appropriately classified as an independent contractor relationship. So in the case of those 33 states, the appraiser could be, and obviously is, providing work and services that is similar to that is done by the hiring entity. In California, those relationships would then not satisfy the B prong of the test. But if that work in these other 33 states is performed off premises, then it does satisfy the B prong of the test, and those relationships can be that of independent contractors. And likewise, for appraisers working in the AMC channel, most of those services, if not all of them, are provided off-site from the AMC, and then do satisfy that B prong of the test in these 33 states. Now, not every state has that off-site allowance. So it is very important, if you are a hiring entity in any of those states, that you take a look at what the law is and work with your accountant and, if necessary, legal counsel to make sure that your workers and your staff appraisers are appropriately classified as independent contractors. And already there have been at least 10 states that have taken at least a initial and cursory look at what took place in California to see if any changes would be necessary to the independent contractor laws in their states. Minnesota, Massachusetts, Rhode Island, and a few others. And of course, the AI will be working with our chapters in those states, monitoring for any changes that could disturb some of these long-established independent contractor relationships between appraisers and appraisal firms, as well as AMCs. So I don't think that we've heard the last of this issue by any means. California likely was just the first, and we didn't see a lot of legislative action on this topic this year for obvious pandemic-related reasons, but next year might be a little bit of a different story and we'll be watching for legislation and then determining and evaluating what action is warranted to protect appraisers and appraisal companies. So I appreciate the opportunity to be with you all today, and certainly if you have any questions, please reach out to us. Our contact information is on the AI website, and please feel free to reach out to us, and we'll be able to help you in any way that we can. So with that, I am going to turn it over to Brian Rogers for some federally related regulatory action on this on a similar topic. So Brian, take it away.
All right, well, thank you, Scott, and thank you, Bill. I'm Brian Rogers, Manager of Federal Affairs for the Appraisal Institute. I work with Bill and Scott in the Washington, D.C. office. I cover federal affairs, things happening in Congress and the federal agencies. Scott briefed you on what's happening in the states regarding appraisal labor law, and probably the bulk of the action is happening there, but there are a few things happening federally as well. First is the U.S. Department of Labor. They had recently introduced a notice of proposed rulemaking, and this involved the independent contractor status under the Fair Labor Standards Act. It was published on September 25th, and comments are due on October 26th, so about 12 days from now. It's pretty much a quick turnaround. Comments are welcome from the public, submitted through regulations.gov. We encourage anybody to take a look at the proposal and comment if you wish. Keep an eye out for the appraisalinstitute.org on our website for comments submitted by the Appraisal Institute. We're currently still reviewing the proposal, but we probably, if and when we propose something, release something, we will put it on the website as well for you to take a look at. So let's take a look at the proposal. It's as imagined, it's coming from the Department of Labor under President Trump, so it's definitely being seen as a pro-business rather than a pro-labor proposal. Secretary of Labor Scalia said the proposed rule aims to bring clarity and consistency to the determination of independent contractor status under the FLSA. Critics, of course, are saying the proposal will give employees and corporations too much leeway in classifying workers as independent contractors, allowing them to pay sub-minimum wages and avoid overtime pay. Like everything now, you may have heard there's an election coming up, and the upcoming election will probably play a major factor in whether this proposal will have lasting power. We see, President Trump, if he does not win re-election, this proposal is unlikely maybe to be finalized, or if it is, it could be an item that's quickly reversed by the Biden administration. And also, before we get into the proposal, Congress is also looking at the issue of misclassification of workers as independent contractors. HR 2474, it's the Protecting the Right to Organize Act, adopt some of the ABC tests as in California. We're examining what the impact would be for appraisers since it was written as an amendment to the National Labor Relations Act, which is different than the FLSA, but which recognizes the right of employees to engage in collective bargaining instead of the Fair Labor Standards Act. That said, the B prong of the ABC test could present some issues for appraisers if they are somehow covered by the NLRA. The B prong is the service is performed outside the usual course of business of the employer. So we're watching this bill pass the House, but as of now, currently Congress has no chance of passing in the Republican Senate. However, if the president's election, if the Senate changes hands in the election, this legislation could be on the fast track next session. So it's something we're definitely going to keep an eye on. But let's take a look at quickly at the current policy. The Fair Labor Standards Act requires covered employees to pay their non-exempt employees at least federal minimum wage for every hour worked and overtime pay for every hour worked over 40 hours. It mandates that employers keep certain records regarding their employees. This could be how many hours they worked, what the wages are that they earned. A worker who performs services for an individual or entity as an independent contractor is not that person's employee under the Act. The Fair Labor Standards Act does not require such person to pay an independent contractor either the minimum wage or overtime pay, nor does it require the person to keep records regarding that independent contractor. So looking at the proposed changes to that, under this proposal, the Department of Labor, which has the power to investigate worker complaints about misclassification, said to adopt a few guidelines to test whether workers should be considered employees or contractors. The test would assess whether workers truly in business for themselves, like a contractor, or whether they're economically dependent on their employee as an employee. It would also examine the degree of control a worker has over their work and whether their earnings came from their initiative or investment. You see the factors, it could help determine if a worker is economically dependent on someone else's business or in the business for themselves. That was on the next slide, please. So that you see the bottom is the core, bottom bullet mentions core factors. Those could include, these would help determine if a worker is economically dependent on someone else's business or in business for themselves. We go to the next slide. That's the same proposed changes continue. There's more additional changes. It identifies 3 other factors that may serve as additional guideposts and analysis, including the amount of skill required for the work, the degree of permanence of the working relationship between the worker and the potential employer, and whether the work is part of the integrated unit of production, and also advise that the actual practice of more relevant than what may be contractually or theoretically possible in determining whether a worker is an employee or an independent contractor. So we had this about 30 days to review it and produce comments. So we're going to be taking a look at that. Once again, comments are due 12 days from now on October 26th, and please keep an eye out on AI's website for any comments released. But please consider, if you read it and you have some thoughts, please send them our way, send them to Bill, Scott, or I, and we can include them in comments. And if you have any questions, we can also help explain what's in the proposal. So we can keep the conversation open, because we'll definitely be hearing more of this in next Congress as well. So thank you for your time today.
Yeah, thanks, guys. So a couple of quick questions. So on the California clarifications, the 6 factors that are included under the amendments, are those the same for all of the exempted professions, or are they specific to appraisal?
No, they are the same for all of the exempted professions. And the way that the bill was structured is that appraisers are classified as providing a professional service, along with a number of other occupations and professions who also lobbied the legislature to be included as being exempt from the ABC test. And I'll add that obtaining this exemption was not an easy thing to accomplish, and it was uncertain right up until the last minute that the bill was passed that the sponsor, a woman by the name of Lorena Gonzalez from Southern California, who's been the champion of this issue, it was, like I said, it was uncertain really right up until the last minute that she was going to include the appraisers within the exemptions. But appraisers are included within the definition of professional services, and those 6 factors are applicable to a number of other occupations and professions as well.
So that will potentially, or maybe arguably, help as far as its application in other states, you think? Because it would potentially be carried forward along with the application with other professions.
Yeah, absolutely, Bill. I think, as other states take a look at this issue, now appraisers are going to be grouped, appropriately so, in with accountants, architects, attorneys, so on and so forth. All of those professions being similar in structure to appraisal-related work.
What kind of advice do you have for our members or chapters that are wanting to get ahead of this issue at the state level at this point, seeing what's happening in California and might be occurring in their own state?
Yeah, I would say just to be be vigilant on the news in your state. This is very much a pro-labor driven issue, and I didn't get into a lot of the details of that during my portion of the presentation. But basically, once Dynamex was decided, the pro-labor forces in California, particularly the labor unions, saw that as emboldening them to be able to unionize workers in the gig economy, DoorDash, Uber, Lyft, so on and so forth. So if this type of a proposal were to move forward in other states, it likely would become newsworthy, particularly as it relates to those workers in the gig economy and the platforms that provide those services. So my guess is that you would hear, and our members and chapter leaders would hear something about this really at the early part of the process and at the outset of the process. And at that point, it's time to consult with us, let us review the circumstances, review any proposed legislation, and we can decide then on a best course of action.
On the federal side, it seems that this is going to be hinged largely on the upcoming elections. So we'll be paying close tabs on that. But have any of those have any parties come out at this point, Brian, and on the DOL proposal in particular, is that falling along party lines or industry lines at this point?
It is. I haven't seen much, but as you can imagine, it's very labor versus business responses. And I think it should be noted that if, say, Vice President Biden wins the election and the Democrats take control of the Senate, it's still going to be very close in the Senate, and that's when conservative Democrats might come into play and stop this. Senator Manchin from West Virginia, maybe Senator Sinema from Arizona. So they'll have to be lobbying them pretty hard. Their Democrat senators will have to be lobbying them pretty hard to get their vote. So there's no guarantee that this would be signed into law by President Biden, perhaps, but it's a good chance that it would. There'll be a lot of pressure for them to sign that or to pass that. But it's definitely labor versus business from the get-go.
Well, we'll continue to work on that. Any parting thoughts for our guests, Scott or Brian?
No, none for me. Thanks for the opportunity again to be part of AI Answers.
Yep, same with me. I appreciate the chance, and send any comments our way if you have any questions or comments on the proposal.
All right, thanks guys for your time and your work on this, and we'll look forward to seeing you all next week. Have a great day.
Thanks, everyone.
Thank you.